Hello and welcome to the very first lecture of the Magna Carta 2022, which is basically a crash course for polity for the upcoming 2022 prelims exam. Right? Now, the very first lecture, given the fact that it is a fairly long lecture and very conceptual in nature, has been divided into two parts. We'll look at it in two halves. In the first half, we're going to cover 5 very specific topics. We'll start with rule of law, only to the point that it is relevant as far as the prelims exam is concerned. There have been questions in the past, in the last 10 years, where they've asked you the constituents of rule of law or the implications of rule of law. Not very theoretical in nature, not to the depth that political science students are supposed to know, just the very basics of it. No Latin phrases, no origin, none of that is actually needed. Then we'll move to the types of laws. This is just very conceptual in nature because your prelim syllabus says public policy, polity and the constitution, which means you must understand how and what are the different kinds of laws that exist in the country, how do we classify them, and what are the different permutations and combinations. You will not get a question directly from the second point in the first lecture, but you'll understand the larger ecosystem in which laws operate. From there on, we'll understand the theory of constitutionalism. This has become UPSC's favorite in the last 5 years, where we've seen multiple questions in terms of what is meant by constitutionalism, what is a constitutional democracy, and so on and so forth. We'll understand 3 basic terms: constitutionalism, constitutional law, and the constitution, the difference between the 3, and then we will understand the types of constitutions that could exist in any given country. We'll look at the classifications of it in terms of whether they're codified or not, or in terms of the kind of government the constitution is trying to regulate. Applications of this do come in the prelims exam, where they ask you whether a written constitution is essential for a federal country or not. Then, very briefly, we'll understand the timeline through which the Constitution of India does come into existence. This will conclude the first half of the first lecture. The second half would be in the separate video, the link to which you will find in the description box and of course as a thumbnail in the video itself. We will then start with the types of state systems, where we'll briefly understand the types of democracies, direct and indirect. We'll further on understand the types of direct and types of indirect democracies. We'll understand what is a parliamentary democracy, what is a presidential democracy, what is a semi-presidential democracy, what are your key points of difference between them, what has India chosen to be, and why has India chosen to be what India has chosen to be. We'll also understand from an economic standpoint as well as to what are the kind of economic state systems that exist, primarily 2 in nature, which is capitalist and socialist. And communism is basically an extension of socialism as far as the exam is concerned. We will then move on to understanding the electoral matrix of the country. We'll understand certain key principles of elections, the types of elections, the manner in which elections across the world and in India are conducted. We'll understand the meanings of certain processes. We'll understand what are the comparative differences between, let's say, a proportional representation and first past the post, and why has India chosen to be undertaking the first past the post system for a majority of its elections. What kind of advantages does it offer? Does it also position itself in some form of disadvantage or not? Because questions can often come from this arena as well. Once we are done with this, we'll then move to understanding the types of majorities, the half fraction majorities, which are, say, absolute, simple and effective, and then we'll also understand the 2/3 fraction majorities, which are special 1, 2, 3, 4. Keep in mind that these words, absolute, effective, special, simple, aren't particularly mentioned in the Constitution. So in your prelims questions, you will actually find the entire description or the calculation of the majority in the options, which you have to cover and consider fairly carefully. Once we've understood this, we'll apply majorities to lawmaking in the country. We'll understand what is the difference between laws which are affecting the constitution and laws which are not, and if they are affecting the constitution, to what extent, to what depth are they affecting the constitution. Are all laws that change the constitution called constitutional laws? Do we have a gradation of some form in that arena and not? So we'll cover that as well, and then we'll move to what is I call the spinal cord of polity. This brings polity down to a scientific subject where almost every question in polity can be answered if you understand the 4 golden rules of Indian polity, and applications of these rules will be able to help you to either eliminate the wrong options or reinforce your memory in selecting the right option. And then we'll move to the reading list that you are referring to. We'll correspond to the NCERT and Lakshmikant. I'll give you specific chapters both from the 6th edition and the revised 6th edition, which is basically the green book and the blue book, which I understand is a crowd's favorite. So this is the larger plan, and this is how we're going to deliver the first lecture in 2 parts. We'll start with the first and then we'll move to the second part. So let's actually start with the first. Let's start with rule of law. Now, when we do study rule of law, we understand this in a rather simplistic format. We understand this in a very, very elementary format, right? The primary purpose of law, the primary essence of law as we know it to be, is to create a sense of order when there is chaos. And chaos in a society is inevitable. It is a natural outcome when individuals in a society are supposed to interact with each other. Now, I'd like to start with 2 examples, one from the private sector and the other from the government. Let's start with something in the private sector. Let us say you're somebody who's buying an Apple iPhone, right? So you are a consumer, you're a phone buyer. And of course, Apple India is the company which is selling you the Apple iPhone. Now, what happens is in Latin, what we call quid pro quo. Latin is to English is what Sanskrit is to Hindi. So don't worry too much about it. It's an older language that most people don't use. But because most of the laws were written during older times, so you will see a lot of Latin phrases such as quid pro quo, prima facie, habeas corpus, quo warranto. These are basically Latin phrases that you don't really have to worry too much about. So what happens? Basically, as a consumer, you pay money to Apple India. Apple accepts your payment and delivers the iPhone to you. Now, when you're giving money to Apple, it is under good faith that Apple India is going to give you a qualitative phone within a reasonable amount of time. Now, what each of you would therefore have with the Apple company is what is called a commercial contract, right? Because you have paid for a certain good, they have accepted your payment and they've given you a commodity. So there is an existence of what is called a commercial contract. Now, very similarly, in the government space, we also have a similar contractual relationship with the government, wherein we as citizens allow the government to exist. We are what are called atoms to the government. So we give the government the existence in the form of voting them into power and of course paying them taxes so that they can run the organization of administration. And in return, we are promised security and welfare. Now, this give and take is not necessarily with the motive of profit, but it is still a give and take. It is still a contract of some sort, which is why you could call it what is called as a social contract, right? Now, you have a social contract with the government as a citizen, and you have a commercial contract with Apple India. What is common to both of this is that you do have a contract. Now, let's take a hypothetical scenario. Let us say that the phone that you got, within 1 week of you receiving the phone, starts to malfunction, starts to heat up, and therefore the applications on your phone start to hang, right? Now you immediately call up Apple customer care. If there was no standard operating procedure, if there were no rules and regulations that Apple would have to deal with situations wherein a customer reports with a faulty product in a reasonable time frame, then whether you got a replacement phone or a refund would depend on the mood of the customer care operative, right? In some cases, you would get a refund back or a replacement phone back. In some cases, you wouldn't. Or it may also depend on whether the customer care relative is executive is a relative of yours or ends up sharing a good rapport with you. But both of this essentially makes it a very, very inconsistent, a very unfair, and a very, very selective framework, right? Similarly, when we look at instances of abuse in the government, if there was no law, a set of regulations to control the people in power, then the people in power would have absolutely nothing stopping them to do whatever it takes to be in power, and that sometimes could be detrimental to the needs of society, right? They may want to bifurcate society, they would want to divide and rule, they would want to undertake certain activities which may not necessarily be in the best interest of society, right? And we often say this, that you may or may not trust the Prime Minister, but you would certainly trust the office of the Prime Minister. And that's something that all of us collectively, as the citizenry of the country, wholeheartedly and solemnly believe in. So when you trust the office of the Prime Minister, when you trust the company more than the CEO, what you're trying to basically do is have trust in an organizational setup, a setup which is backed by law. And this gives birth to an idea that we need to trust institutions. We need to make sure that the people in power are controlled by a set of regulations which are also created by the people in power. It acts like a speed breaker nonetheless, but the law must always be paramount. Now, that does not necessarily mean that countries all over the world would always choose rule of law. It would essentially be a quintessential debate, a debate between rule of law and rule of man. And this is a debate better for political science students, not for polity prelim students. But India, like a lot of other countries in the world, have chosen to embark upon the path of rule of law, a Latin word which basically means lex rex, which basically means that the law is supreme. Whoever is in power, whoever wants to do a damn thing in the country, will only be able to do so because the law gives you the power to do so. Even if it is a discretionary power, even if it is a power that allows you to act on your own, allows you to independently take a decision, it's because the law allows you to do so. Even if the governor has a discretionary power in our country, it's because one of the laws in our country, in fact, one of the highest laws of our country, the Constitution, empowers the governor to do so. Tomorrow, if you do become a civil servant, and for those of you who are aspiring to get into the administrative services, you will have certain extraordinary powers. You as district officials, particularly at the SDM and the DM level, would have powers to impose a curfew. You were all incident commanders, especially when the country was surviving a pandemic. Who gave you the powers to lock down your district? The Disaster Management Act does. Who gives you the powers to impose a curfew? The Criminal Procedure Code does. So whether it is the Disaster Management Act or the Criminal Procedure Code or the very Constitution of India, any power that any authority in India has is derived from the law. You want to alter the power, you want to increase or decrease the power, you've got to do it through a change in law. And that is why we say the law is supreme. But the story doesn't end here. The story doesn't end here, because if we are saying that the law is above everything else, we're also saying that everything else is beneath the law. If I had to draw an analogy, so those of you who are religious would say God is supreme. So if God is supreme than humanity, then humanity is inferior to God. But unlike God, whose supremacy you can't challenge, unlike God, who you can't cross-question and say, does the God deserve to be supreme? Here, the law does deserve to be supreme. You can question the fact whether the law is good enough, worthy enough for us to place it above everything else. And for that, you can subject the law to two tests. These two tests are called procedure established by law and due process of law. Procedure established by law is whether the law was passed in the right manner, whether the law is following a certain procedure, and whether an act or whether an activity or an action that happened in accordance with the procedure which is mentioned in the law. It doesn't matter whether the procedure is right or wrong, whether it is for the good of us or not. This is a very, very rudimentary, this is a very, very, you could say, a very, very basic way to analyze whether the law is good enough. If it is passed in the right manner, implemented in the right manner, followed in the right manner, that's it. That's all that matters. This is called procedure established by law. On the other hand, you've got due process of law. Due process of law is more of a grown-up discussion on the law. Did you pass the law for the right reasons? The law was passed for reason X, but is being used for reason Y. Is it justified? Is the law serving the purpose with which it was originally passed? You question the legislative intention of the law. You question the very purpose of the law. And that is called due process of law. Of course, due process of law is far more subjective. Procedure established by law is far more objective. The difference between procedure established by law and due process of law, quite frankly, is the difference between an arranged marriage and a love marriage. So, an arranged marriage is procedure established by law, where the parents are compatible, the families are compatible, both of you do the same kind of work, and therefore it makes sense for you to be together. But due process of law is, do you believe in the same things? Do you want the same things from life? Do you have what is called, quote unquote, a wavelength or a compatibility match, right? So that's the basic difference. And of course, like in India and everywhere else in the world, arranged marriages happen before love marriages. So due procedure of procedure established by law predates due process of law. It originally has been formally found in the Japanese Constitution, which is why most of your textbooks credit procedure established by law to Japan. But there have been several instances of UK jurisprudence also referring to procedure established by law. And because the origin of procedure established by law cannot be said for certain to come from Japan, you will never get a question in the prelims exam that says, where did procedure established by law originate? Though it is easier to implement, and this is fairly systematic to take note of, which is why, and several provisions in our constitution, for instance in Article 14 as well, you will very clearly find the words procedure established by law, very clearly. However, when you look at due process of law, this is poetic in nature, this is extrapolatory in nature, and we know poetry and extrapolation is a thing of the courts of our country, and therefore the Supreme Court, through a multitude of its judgments, has evolved and has applied principles of due process of law to several instances. One of the most popular ones, of course, is the Menka Gandhi case of 78, where the Supreme Court said that no doubt procedure established by law is a part of us, so is due process of law. It basically expanded the definition of the same. So, in your prelims, very clearly, procedure established by law explicitly mentioned in the Indian Constitution, due process of law derived through Supreme Court judgments. Origin of procedure established by law, of course, UK or Japan, and UK because it's older, whereas the origin of due process of law is the United States because it is a relatively newer democracy than UK, where it has often been quoted as jurisprudence. This should be more than enough for you to answer questions on rule of law. I recall certain previous questions where they've asked you, rule of law implies what? So rule of law is nothing but making sure that the government or any authority in power is kept under check in the best interest of the people. That's exactly and simply what rule of law means. Everything else is irrelevant. The question in the prelims that was asked last year, not last year, but a few years before, was whether rule of law places any obligation on the citizens. Of course, that was the incorrect option. So rule of law is basically obligations on the government to ensure that governments are kept in check and citizens' interests are always paramount. So that's what rule of law is. You don't need to know the Latin phrase. You don't need to know somebody called A.V. Dicey. Nobody's really going to ask you all of those things. But this is your first topic called the rule of law. Now that we understand that India has chosen to be a rule of law country, the next question often is, why has India chosen to be a rule of law country? The 4 reasons that I'm going to give you are 4 reasons which justify any principle-based decision that India has ever taken. For example, why are we a parliamentary democracy? Why have we chosen a first past the post system? Why have we not chosen a proportional representation system? Why do we have a center stronger than the states? Why do we have an independent judiciary? These are 4 reasons that you can cut, copy, paste anywhere you'd like. The first reason, of course, is our imperial past. Now, our imperial past means when you've had 200 plus years of colonial rule, not only are you scared of foreign government, you're also scared of government in general, because as you would have noticed through your studies in modern history, there were several Indians who were a part of the British administration, not only in an administrative capacity, but also in a military capacity. So therefore, you always wanted the government to be in check. And the best way to do that, the best way to prevent government malfeasance is to ensure there is a rule of law. And that is what is meant by an imperial past. Second, our second reason is, of course, the nature of federalism in the country. Now, federalism anywhere in the world means the existence of 2 layers of government. If a country has a center and a state, the country is a federal country. Now, how federal is a federal country is a matter for another time. But India, as we understand through our discourses, is an involuntary federation, which means that in India, unlike the states where we often compare ourselves to, where 13 British colonies decided to come together and on 4th of July 1776 declared to become independent and collectively come together, make a group and call it the United States of America. Contrary to that, in India, the center came before the states. In the US, the states came before the center. And when the center comes before the states in India, it was the responsibility of the center to make sure that its federal units or its future provincial units were integrated. Now, you could convince them, corrupt them, or convict them. And often there were elements of coercion in place. So, and whenever you see a power balance shared between the center and the states, nobody will give both the elements equal powers. How do you convince the states that your interests are going to be protected? How do you convince the states that the center is not going to cross a line and step into territory of administration or territory of governance which is largely yours? by telling the states that there is going to be a law that is going to prevent the center from doing so. That's the second reason why rule of law is important. Third, the third and a fairly important reason, of course, is the socio-economic status of India. To give you a little bit of context, when we became independent and when the first census was conducted in 1951, we fairly understood that the literacy rate of India was not even 20%, which means 80% of Indians were illiterate. The female literacy rate was under 10%. That means 80% on an average, and 90% of women in India couldn't read and write. So in a country where a majority of your population is illiterate, people in power could abuse this illiteracy and therefore could look at gaining for their own good. And the only way you could keep that in check is by ensuring a set of rules, a set of laws that prevent the people in power from again crossing a line. And fourth, of course, is the inherent diversity of India. Unlike the US, which is often considered to be a melting pot of cultures, India has always been home to all cultures, all religions, all communities, all castes since eternity. And whenever there are multiple classifications of cultures and subcultures in society, there will always be conflict. There will always be a race for domination. There will always be a majority, there will always be a minority. And whenever there will be a minority, the minority may or may not often be disadvantaged. And that is why you would need the law to protect the minority, to make sure that the minority gets ample opportunities to advance itself, to develop itself, so that it could again have an equal platform for enhancing their own abilities. So for all of those reasons, in fact, and the only way you could do that is by making sure there is a law which protects the minorities and prevents the majorities of any kind, could be religion, culture, caste, anything, to make sure that everybody gets their due. And for these four foundational reasons, India chooses to be what is called rule of law. And this is the only philosophical discussion I'm going to ever have with you, because now we get down to business, and the business begins with the types of law, right? Now, let's look at the types of law. See, largely, you could classify laws into four types, and they're interchangeable in nature. So, a law could be of a certain type, could also be a certain type with another classification, and so on and so forth. These are not watertight categorizations, but laws are generally classified into four types. First is, of course, who is the law for? The target audience of the law. Second is, what happens when the law is breached? What is the nature of the law? Third is, how in-depth is the law? Is it superficial in nature? Is it extraordinarily detailed in nature? What is it in terms of the depth of the law? And fourth, of course, how is the law used? So these are the four ways in which you could classify laws. Let's start with the first one. I'll keep it simple, I'll keep it brief, and I'll keep it concise. Broadly, there are three kinds of laws. First, of course, is laws which only and generally concern the government. How does the government function? What are the kind of responsibilities and limitations that exist on the government? For example, the Constitution is a classic example of a law which governs the government, right? The Constitution is primarily a law that governs the government. It gives us protections against the government, but beyond that, it lays down the structural operating mechanism for governments to function, right? Similarly, your rules of procedure for your legislative houses, they're also a kind of a law. They may not have to be passed by the government, they may not have to be passed by the parliament, but a rule is also a law. A law is anything which is legally enforceable. So a rule is a law, an order is a law is a law. So those are laws that primarily concern the government. And then there are laws which primarily only concern citizens. They tell the citizens what they should or they shouldn't do. For example, the Motor Vehicles Act of 1988. Then there are, of course, laws regulating private entities. Now, private entities could be for profit, could be non-profit. So the Companies Act, which was sort of revamped in 2013, is a law which primarily governs private entities. It governs both profit and non-profit companies. Similarly, for non-profit entities exclusively, you've got the Trust Act, the Societies Act. You also have specialized laws such as the Foreign Contribution Regulatory Act of 2010, which governs how non-profit entities receive overseas donations. And this, of course, has been in the news for all the wrong reasons, at least for the past couple of years. But this is largely what a law is on the basis of its target audience, right? Now, similarly, the next way in which you can classify laws is the impact of the law, right? Now, when we look at the impact of the law, we say there are essentially two kinds of laws. There are civil laws and there are criminal laws. So what is civil and what is criminal? Basic. The violation of a criminal law could either send you to jail, or could ask you to pay a fine, or could ask you to do both, or in very rare cases, sentence you to death penalty. It's that simple. A civil law primarily will ask you to either pay a fine, or to compensate, or to ensure things return back to normal. Right? That's the basic difference between a civil and a criminal law in terms of what are the outcomes of its breach. Secondly, because India follows what is called the common law system. Common law is a set of legal principles which all former colonies of the UK have adopted, which is why it's called the common law. Very similar to Commonwealth, which is nothing but an organization of nations which were previously UK or British colonies. So one of the principles of common law is that a crime is committed against the state. It is the failure of the state to protect the well-being of the people, and that is why the crime has been committed against the state, which is why you will often see criminal cases in India are usually as, say, state of UP versus X. On appeal, it could go to X versus state of UP. So on and so forth. So that's the second difference. So a civil law could be between two parties, but a criminal law in most cases is usually against the state. Usually against the state. Not always, but usually against the state. So that's the second difference, right? Now, so for example, the Contract Act of 1872, a very old act. I will tell you in some course as to how pre-independence legislations get to still be enforced in India today. We'll come to that in just a bit. But for example, the Contract Act, it's the most basic, it's the foundational law governing for-profit relationships between entities, organizations, and human beings, right? It's a civil law. Violation of the Contract Act would ask you to pay a fine, would ask you to compensate, would ask you to bring things back to how they were. In legal terminology, we call it restitution, right? Or specific relief also by extension. Then you of course have criminal law, right? Now when we look at criminal law broadly, for example, is like the prevention of children against sexual offences, the 2012 legislation. It particularly deals with offences which are committed against children, which are sexual in nature. The Indian Penal Code is a criminal law. The Juvenile Justice Act is a criminal law. Prevention of Immoral Trafficking Act is a criminal law. So these are what are generally called criminal laws. Then you also have something called the depth of the law. Right, now let's understand this. In civil services reforms, we often hear a debate between generalization and specialization, that you guys, as in when you clear the civil services, are trained over such a variety of subjects that you often are not able to develop expertise in one particular line of governance, which is why specialization becomes a fairly important argument to reform the civil services, on the basis of which several initiatives such as the lateral entry scheme has been introduced more vigorously now, because you need specialization. Similarly, the same logic also applies to laws. Like for example, let's take the case of a general law. The Indian Penal Code is India's largest criminal law. It contains provisions of basically two things. One, defines what a crime is, and second tells you the punishment for it. But it tries to cover as many crimes and as many punishments. If a single law is going to cover as many crimes and as many punishments, it will try to be the jack of all trades but a master of none. It will not be able to get into the depth of a crime, look at how crimes have evolved, get into specific detailing of a specific nature of crimes. So for example, the Domestic Violence Act particularly focuses on violence that is meted out to either live-in partners through Supreme Court judgments or wives by husband, friends, relatives, etc. It specifically looks at matrimonial violence, a dedicated law, an entire piece of criminal law only on matrimonial violence. Whereas your Indian Penal Code will have just one section, section 498A, if I remember correctly, which refers to matrimonial violence, right? So the Indian Penal Code in this context becomes a general law, and the Domestic Violence Act or the Dowry Prohibition Act or the Juvenile Justice Act or the POCSO Act, they become specific laws, very, very specific laws. So that's another way to classify laws. And then of course is the way the laws are used, the usage of the laws. Now let's understand this. Because we are a rule of law country, and rule of law has two ingredients: procedure established by law and due process of law, which means there is going to be a system of doing things. You're all getting into the bureaucracy at some point of time. You'll understand procedures are more important sometimes, if not as important as the substance, which is why you often have two kinds of laws: procedural laws and substantive laws. So what is the difference? Substantive law is which tells you the content, and procedural law is how do you go about it if the law has been violated, or how do you implement the enforcement of the law. For example, the Hindu Succession Act of 1956, just a random law that I'm quoting, is a substantive law. It tells you how property has to be transferred in a Hindu undivided family, so to speak. Whereas if there is a property dispute, which court will you go to? How will you approach the court? What are the documents that you are going to submit? All of this is under the Civil Procedure Code of 1908. Similarly, the Indian Penal Code is a substantive criminal law, whereas the Criminal Procedure Code is a procedural criminal law. So these are largely the ways in which you can classify laws, and therefore will make you understand the types of laws, just very, very basic. Which means when we look at our itinerary, we're covered with the first two topics. Now that we understand there are something called a rule of law, we understand there is something called the types of laws, we now move to principles of constitutionalism and of course the types of constitutions. So let's start. We understand that there is a need to govern the government, right? I'm sure as public administration enthusiasts, you would have definitely heard of a saying which says, absolute power corrupts absolutely, right? The only way you could keep a check on absolute power is to ensure that you're able to check it through law. If you are somebody who believes that the people in power must be controlled in terms of the power that they have, you are very proudly a constitutionalist. So constitutionalism is nothing but a political theory, a theory which says state powers or powers of the state should be limited or should be controlled, should be limited or should be controlled. It's that simple. It is of course to be controlled or limited by law, and we're going to come to that in just 5 seconds. But the theory, the principle is that the powers of the state must be limited, must be controlled. And if this is your theory, it must be put into practice. And for it to be put into practice, we understand something called constitutional law. So constitutional law is any law of any nature. It could be passed in any form, which limits or restricts the powers of the state. Keep in mind, state with a capital S means the country or the nation. State with a small s means a province or a federal unit. Of course, in political science, you would have longer discussions on the difference between a nation and a state and a nation state. But thankfully, we don't have to worry too much about it. It is beyond our academic purview. So a constitutional law is any law which restricts the powers of the state. It could be one law, it could be 10 laws, it could be 50, it doesn't matter. So what is a constitution? If there is that one single comprehensive compact law, that one dedicated law, that one specialized law, whose responsibility it is to structure and regulate the government, then that document is called the Constitution. Then that document is called the Constitution of that country. And because it is a single document governing the government, it automatically would become the highest law of the land. It would be treated more specially, with a greater degree of dignity, with some speciality, as opposed to other laws. So the basic underlying principle is, all constitutions are constitutional law, but all constitutional laws are not constitutions. So India has a constitution because it is one single document. The UK doesn't have one single document. The UK would therefore have what is called constitutional laws. The Human Rights Act of the UK would give fundamental rights equivalent to the people of UK. But in India, from the rights to the establishment of the machinery, everything is in one document. If you think about it, before independence, the Government of India Act 1935 was actually a constitutional law, because that law was regulating the structure of the colonial Indian government, so to speak. So, all constitutional laws are not constitution, but all constitutions are necessarily constitutional laws. Now that we understand this, so a constitutional democracy is a democracy which has a constitution, or a democracy which believes in a limited powers of the government. So you can add any word after this: a constitutional republic, a constitutional democracy, a constitutional government, a constitutional state, and so on and so forth. The meaning would remain the same. What we really need to understand is, constitutionalism is an idea where the powers of the state are controlled as a necessity. And once we understand this, we then understand the types of constitutions, right? Now we understand the types of constitutions. And to understand types of constitutions, just a little bit of theory. What is it that the constitution is supposed to do? Now, this is of course very basic, and some of you may find it to be too basic for your liking, but because this is in your NCERT and the UPSC often picks up lines from your NCERT, these are your 5 basic functions of a constitution. For example, first, basic rules for coordination amongst society members. We do that through fundamental rights, we do that through the parliament, the legislatures, and so on and so forth. 2, allocation of decision making in a society and determining government constitution, or the constitution of government. So of course, allocation of power, who gets to decide, who gets to make laws, who gets to implement laws, who gets to keep a check on laws, how do governments get formed, when do they get formed, what are the conditions for you to contest government, what are the conditions that debar you from contesting government. All of that is of course in the constitution also. Then setting limits for the government powers over citizens. Our fundamental rights are precisely there for this very reason, to enable government to fulfill societal aspirations and create a just society. your directive principles, a certain sense of a governance agenda for the government, essentially also gets to do the same. And last, expressing the fundamental identity of the people. This could mean two things. First, the political identity, and second, a moral identity. A moral identity would mean the collective moral consciousness of the people, which is also reflected in the kind of rights that you're guaranteeing to the people. And a political identity would mean granting people equal citizenship, giving them equal rights, giving a certain section of people more rights than the others. So these are the functions. The reason I wanted to list them out for you is because they're in the NCERT and therefore it becomes important. Now, when we look at the classification of constitutions, there are primarily two ways of classifying constitutions. First is the number of layers the government has. Second is the degree of codification. Now, this might seem a little complex to you, and we'll come to that in just a minute. So, when we talk about the layers of government, what we're basically saying is, does the country have a single layer of government or a dual layer of government? If you have a single layer of government, then it is called a unitary form of government. There's just the central government. There is nothing called the state government. There is just one government, right? And second, of course, is a federal government, a country which has at least two layers of government, the central government and the state government. Another word for a state government would be a regional government or a provincial government or a federal unit government. So essentially the same thing. Now, you could have a unitary constitution for a country which has a single layer of government. Even if you don't have a constitution, it is fine because there is no conflict of powers as such. But if you do decide to have a constitution, great and good to go. Singapore is of course an example of the same. Also because it is such a small country, you don't need multiple layers of government, so to speak. But when we do talk about federal governments or federal states, where you have at least a center and a state government, and we understand that power cannot be distributed equally. No parent loves both the children equally. Somebody would be somebody's favorite. So in the same way, when there is a central government and a state government, either the central government will have more powers than the state government, or the state government is going to have more powers than the central government, right? If the central government has more powers than the state government, then it is called a federal constitution with a unitary bias, to which India is an example of. Or if the states have more powers than the center, then it is called a federal constitution with a federal bias, and therefore US becomes an adequate example of this. So this is how you could classify a constitution, on the basis of the layers of government, which is also why if you have two layers of government, you would definitely need a law very clearly determining that central government has X powers, state government has Y powers. And that law, of course, is the Constitution, which is why a written constitution or a constitution is essential for a federal government. Now, we come to the second way in which constitutions could be classified, which is basically the degree of codification. Now, let's understand this, right? For those of you who are students of law, you would probably understand this, that there are something called oral contracts, right? Oral contracts in the sense that you went to a shop, you spoke to the shopkeeper and you shook hands on it that, okay, I will buy this commodity of yours at a specific price. You shook hands, you made a deal and you came back. In the evening, the shopkeeper calls you up and says, sorry boss, I've gotten a better deal somewhere and our deal is off. Well, that is a gray area. Though oral contracts in India do have some legal value, but that's again not the purpose of our discussion today. The idea is, when we talk about degree of codification, we're talking about written laws. We're not talking about unwritten laws. There is no such thing called an unwritten law. We're talking about whether it is written as a single law or multiple laws. If it is written as a single law, if the Constitution is written in one single document, it's called a written constitution. And if it is written in multiple laws, law 1, law 2, law 3, law 4, then it's called an unwritten constitution. An unwritten constitution does not mean that the constitution is not written anywhere. It simply means that it's not written in one place. And that's the fundamental difference. Which is also why, if you have two layers of government, it makes so much more sense to have a single law which will govern the relationship between two layers of government, thereby now making it necessary that a written constitution is essential for a federal layer of government. And that's what a written constitution is. It's a single, one-piece, comprehensive, compact document. And of course, India and the US are examples of the same. On the other hand, you could also choose to not have a single written document, like the UK does, as I was telling you. So UK will have a separate Human Rights Act, a Parliament Act, a Supreme Court Act, and all laws will be treated as good as each other. If you don't have that one single law, you will not be able to treat that one single law specially. You can't treat 10 people in your life specially. You've got to treat one person in your life specially, right? And that is exactly why you need to have a written constitution. So the Parliament of India can't wake up in the morning tomorrow and say, we're going to get rid of the Supreme Court. They can't do that. But the Parliament of the UK can wake up tomorrow morning and say that, boss, we don't need the Supreme Court. Okay, tata, bye-bye. In fact, you would be very surprised to know, until 2010, UK didn't even have a Supreme Court. The upper house of the UK doubled up as the Supreme Court. So that's the basic difference. You're not able to give the right kind of sanctity and protection to essentials of a good state unless you have a single written document. And especially for India, with an imperial past, with an involuntary federal setup, with the diversity that we have and the socio-economic conditions that we had, it also further necessitated that we must have a single written constitution. It really does make a lot of difference to the way we are as a country. And that takes care of the types of constitutions, right? Now that we understand the types of constitutions, we shall now look at, very simply, the timeline of India's constitution, right? Now, see, in physics, we often say that matter cannot be created or destroyed, it can be transferred, right? Or energy. Pardon me for being not very accurate with my scientific explanations, but that's the gist of it. Similarly, power cannot be created or destroyed, it can always be transferred, right? Now, India was a colony for a long time. The British had the powers over us. So when the British leave, there are two questions. One, power has to be transferred, and two, power has to be transferred to someone. And that's the genesis of understanding the timeline of India's constitution. So how it works basically is that the Government of India Act of 1935, which was a British legislation, had set up something called provincial legislative assemblies. They were the base to setting up something called the Constituent Assembly, which we'll come to in a bit. Indirect elections were to happen to provincial legislative assemblies. Indirect elections is when you choose someone who then chooses someone else. That's an indirect election. Now, in 1946, we had something called the Cabinet Mission Plan. And of course, you will do this in a fair amount of detail in your modern history, and I don't want to burden you with this at the moment. So, with the application of the Cabinet Mission Plan on the guidelines of the Government of India Act 1935, we set up something called the Constituent Assembly. This is supposed to be the transition organization. This is where the British will leave the power to. And they have two things to do. First, to draft the constitution, and two, to run the country until the first proper elections happen, right? So of course they had in India we had about 292 provinces and 93 princely states. These 292 provinces were given a certain number of seats in the ratio of 1:10 lakh, and of course across three communities, the general, Muslims and Sikhs. Generally included Hindus, Buddhists, Jains, etc. And this was done on the basis of proportional representation and a single transferable vote. What this is, we'll talk about in the next lecture, what these terms mean, so don't worry about it. And the 93 princely states, representatives of the 93 princely states would be chosen through a consultation basis. But here you would have seats allocated to 3 communities, and this was all done through a process of an indirect election. The Constituent Assembly for the first time sat on the 9th of December 1946, and the eve of the partition sat on the 14th of August 1947, and these seats were reduced because we had unfortunately, because of the partition, the areas which were then given to East and West Pakistan at that point of time had to be reduced from the composition of the Constituent Assembly. But what happens? How does the transfer of power take place? So, the government of the UK passes what is called the Indian Independence Act in 1947, which does 2 things. First, legally partitions India, and 2, transfers the power to the Constituent Assembly, which had been constituted as per the cabinet mission plan. It's not something that we as freedom fighters came up with. It's something that was sanctioned by a British policy document called the cabinet mission plan. And that's how the Constituent Assembly also became the interim parliament until the first elections happened a few years later, right? So, and of course, Jawaharlal Nehru was also the interim prime minister. All of that is fine. But the first formal general elections didn't happen for the next 3 years, for sure. And that's how the Constituent Assembly had 2 things to do. First is to also be an interim parliament until elections and the first formal government comes to power. And second is to draft the constitution on the basis of which elections will happen in the times to come. Right? So that is how it went. So the Constitution of India was adopted by the Constituent Assembly / the interim parliament on the 26th of November 1949. Some provisions were implemented, not all, but all the provisions came into force. The Constitution as an entire document was applicable on the 26th, from the 26th of January 1950, which is also called the Republic Day. This is also in commemoration of the 1929 Lahore session of the Congress, where we had for the first time demanded what is called Poon Swaraj, and 26th November 1949, and the date 26th November is also observed as a Constitution Day or Law Day even today. But this is what is Republic Day. This is where the Constitution comes into being as a whole, as an entire document. Now, when we're looking at the types of Indian laws, we saw that the Indian Penal Code dates back to 1860. We still use the Indian Penal Code today. It's because the Constitution allows for pre-independence laws to be adapted post-independence. This is done through Article 372, Clause 2. Article number is not relevant. The President, through an order, is empowered to adapt pre-independence laws to post-independence, and adaptation law orders were passed. There were several adaptation orders, 1948, 1950, 1956 also, where of course provisions of the Indian Penal Code were made applicable to post-independent India. So that's how pre-independent laws also come into play, and this is how power gets transferred from the British administration to us, right? You would remember 1857, power gets transferred from the East India Company to the Crown, and then of course in 1947 from the Crown to the Constituent Assembly. And that's how the Constitution sort of comes into being, comes into power, comes into essence. So of course you've had your drafting committees, you've had your Constitutional Assembly debates, all of those things are there. They're important for the mains, not particularly for the prelims. Gone are the days where they ask you who the members of the committees were, what were the viewpoints and all of those things. That's not particularly relevant as far as the prelims is concerned. So adopted on 26 November 1949, enforced on 26 January 1950. And this is very briefly and very broadly the timeline to India's constitution. I've been able to get this again, I think, from one of your NCRTs of class 11th, Indian Constitution at Work. At the end of the second lecture, which is the second half of the first lecture, you will find relevant links, relevant citations to the books that you have to refer to, or the pages in Lakshmikant that you have to read. We'll come to that in just a fair bit, right? So this sort of covers the first part of the first lecture. So we are done with rule of law, types of laws, constitutionalism, types of constitutions, and India's constitutional timeline. We'll start with the second half of the first lecture from the types of state systems. Thank you for watching. Stay tuned.